extremely pleased to have with me today Dr. Professor Shashikala Gurpur, Director of Symbiosis Law School, Pune. She is a recipient of the Legal Education Innovation Award and a member of the 19th Law Commission of India. Thank you so much for being here with me, ma'am.
Thank you, Neha. It's a pleasure to interact with the CMC and your initiative. So I'm looking forward to our talk.
Yeah. Thank you, ma'am. Ma'am, after listing only some of your many achievements, I would like to begin this interview by asking you to share with us some of your background and experiences in the field of ADR.
Neha, I have two dimensions to give here. I think more than two. One is my own personal experience of looking at how dispute resolution, which is the mainstay in justice delivery, is more effective in terms of non-judicial, non-adversarial approach. Why it is more beneficial? I was growing up in a household which had 4-generation litigation for the inheritance. We had huge parcels of land in a remote village, which was passed down to us by our great-grandmother, about 400 acres of land. It was almost 3/4 of the village. But by 1970s, land reform came. So we all were dividing these land between ourselves, but there was no unanimous opinion, because even though women inherited the land, there were their husbands who had different opinion and expectations. There was a male heir who came in my mother's generation as well. So by that time, India shifted to matrilineal to Indian Succession Act, Hindu Succession Act, etc. So when my grandmother made a will, willing away the property to her grandson out of the male buyers, we had to challenge that. So I was one of the litigants in that, one of the heirs who was impleaded in that. My sister was an unborn baby, but it was very unique that she was given a name and she was impleaded as an heir. So this litigation started before she was born and when I was 2-year-old child. And then it continued when I was in college. My father was detected with a severe life-threatening heart disease. So doctor called me. I was a very studious student of science, got admission almost in JNU and in Institute of Science for pursuing higher studies. But the doctor called and said, whoever it is in your family has to handle these responsibilities. The stress cannot be handled by him anymore. The lesser the stress, his lifespan will increase. So that day, coming out of doctor's chamber, I determined that I will handle this responsibility. Although I knew nothing about law, court was a kind of a mystical space where women dreaded to go in small towns where I was growing up. But I decided, I did not know my limitation also. I just had the enthusiasm, courage, and the responsibility. So I started leafing through. Nothing I could understand about the litigation or papers. And in lawyer's chamber, if you go, it's talking down to you because it's paternalistic professional approach in small towns. And in those days, I'm talking of early 80s. So then I started reading Constitution. Although I had read it as a student of civics, I had read it only to pass the examination. Now I started applying it to my life. And by the time I was in my final year, I was a very well-known debater in the university circles, was a state award winner, was going to the national level. So I had the oratory. I could articulate ideas, understand. I was sharp in picking that up. And I was writing articles, etc., short stories, etc. So therefore, communication was there. I didn't know what were the competencies, how you prepare for law, etc. So I went to the law college, only law college in that town, just to have a feel for a debating competition on the constitutional dimension. And I was a champion in that debating. So while coming back, I felt this is the place where I have to continue my studies. I liked the liberal approach of the professors because in science, it's very regimented. Whereas here, it was everything they were talking and they were talking with that command and the clarity. So I decided to join the law school after BSc. I remember the principal dissuaded, saying, having 98% in botany, are you in the right frame of mind to come to this law school? Because here nobody scores that well. I said, I'm driven by circumstances. So first year, I started networking and then I started attending the court, meeting lawyers, studying documents. By the time I was in second year, I realized that litigation is going to damage our relationship. It's going to cause huge social capital loss. It is going to leave a kind of bitter aftertaste even if we win the litigation. And secondly, when you go for property partition under CPC section 54, once the court decides your quantum of share, it goes to the revenue department. And in every state, procedures are different. And once it goes to the revenue department, the IAS officer sits in his cabin and he says, this part is to X, this part is to Y, without realizing where the water reservoir is, where are the boundaries, etc. So I convinced, my father was very, very ill by that time. I convinced my mother. I asked her first question, do you want relationship? Do you want more arrears and more property? She said relationship. And then we started. I mean, we used many kind of social skills which I had mastered by then being in the law college politics, because law college had the All India Student Union, all law college student union presidentship as well, and I used to campaign for them. So I was quite popular. I had a good network. We went and we spoke to our relatives, and then it was brought to the table. We mediated, and we lost a little bit of our expectation. About 30% we lost in terms of arrears and other things. But we wanted to have the ancestral household as the girls, so that we got. And then we continued our family relationships. And to this day, we earned more relationships. We earned peace of mind. We were able to get the property to hand, which we sold partially, to settle a lot of our other commitments and plan the future for all four of us. I went to Bangalore. I left Bangalore after 5 years. I went to Bangalore National Law School. I was invited by Dr. Menon to join. From there, my life took a different shape. I went to Ireland. I met an Irish law professor, married him, went to Ireland, made family there, came back to India. So I brought so much of best practices to legal education. And when I got this forum, my first attempt was to use the law school as because my earlier law graduation where I done in a small town, afternoons we used to spend time with poor litigants and people. Students were supposed to go to the court, watch the client behavior. So when I started my law career there also, first 5 years, after my teaching, I would come home very late. My mother used to say in the neighborhood, there's another lecturer who comes home by 3 o'clock. I used to spend my time with the poor, go with them to the revenue department, get them ration cards, get them deprived shares in the property, etc. So my own struggle, I tried to look at from others' point of view. I was also inspired by Gandhi's life, where he was such a person who could persuade the entire nation to move on a theme, but he chose not to fight the case in the court, but to go for ADR. So I was watching, so when I started, that was all over by 1991-92. I moved to Ireland by 95, came back by 2000. And then when I took up this job in 2007 after a stint in corporate, and also I worked when my son was growing up, I did not want full-time job. So I was developing a movement on gender and human rights. And I was supporting these women who were dowry violence victims, who were domestic violence survivors. So we generated a 5-point NGO, and that NGO even presented a public hearing on a dowry death case and got the judgment reversed. So I was doing a lot of activist work for women at that time. And that was the time I realized that we need to move exclusive work on rights and justice. So we used to teach women how not to leave their home. I'm talking about Pre-Domestic Violence, Prevention of Domestic Violence Act, and also POSH. So we used to teach these women not to give up, to articulate, to question, to oppose, but to remain in that place. So a lot of alternative resolutions we were teaching them from the vantage point of social reform and vantage point of persuasion. So this has worked to the advantage by women not being fired, women continuing there in their household, not giving up their possession and control. So from there, when I moved to Symbiosis Law School as a director and dean, I started studying the clinical courses. I started studying the dispute resolution dimension. It was taught as an academic subject. So I started looking at how to make it more clinical, because we were inspired by my mentor, Dr. Madhav Menon, on looking at legal education like science education and medical education, learning by doing. So in the first year itself, we were able to motivate this national level clinical legal education seminar. We brought a lot of best practices and we started experimenting. So by about 2008, Dr. Menon inaugurated our first village clinic in Pirangoor. You know, the first thing we did, we caught hold of the panchayat members, did the capability building for them on how to prevent disputes, how to resolve disputes so that the village harmony is not disrupted. Because I myself had grown up in such environment. My father was a one-man army. He was like a one-man mission in resolving disputes. So disputes were resolved in the village level. So that village got Mahatma Gandhi Tantamukta Yojana award. It was the ISO certified panchayat. So Pirangoot village panchayat work, along with the other interventions in legal aid and legal awareness we made, inspired us to bring it to the fore. So when I became the law commission member, I held the first national workshop on improvement in justice delivery system. And one of our clients from the village came and spoke on why ADR is important. He spoke about his own personal life and what kind of advantages came to him because he was empowered to resolve dispute peacefully outside the court. And long-standing litigations were brought to an end by happy, satisfied parties. So then we started, this is one avenue of legal aid and then capability building and making the villagers to or citizens themselves to look at how they can assist the dispute resolution. Second avenue we created was capability building for the faculty. We made faculty go through these different alternative dispute resolution mechanisms so that faculty can make it a part of their curriculum or part of their pedagogy or part of their field exposure to the students. So clinically and learning by doing kind of avenue, faculty were enabled. Virtually there is no subject where dispute resolution techniques are not taught and alternative dispute resolution is not taught, either as a tool or as a technique or as a content. Then we looked at working with the District Legal Aid Services Authority and going into Mahalok Adalat. Every year, 45 to 50,000 disputes get resolved through Pune's DLSA. We worked with them by volunteering through our students, etc. So on one day, for that 2-3 days prior, we will start the preparation. So many disputes will be resolved. So studying those documents, filing them, assisting the client, this job is done by our student. So we started looking at ADR techniques to be mandatorily mastered by all the students. So every batch which comes, as soon as they come, they are exposed to these techniques. They are divided into small groups and experts come and run these workshops. The last avenue which I want to tell you about in terms of ADR is all the law schools are obsessed with this idea of moot courts and student bar associations, only preparing students for national level moots, international moots. There's a very rare initiative which is taken by Goa Law School, Salgaonkar Law School, that is called Louis Brown Client Counseling Competition. So that competition was something that inspired us to look at alternatives to moot. So in our law school, we don't call it as moot court association. I changed its name as Student Bar Association. And comprehensive lawyering is what we started doing. So now we earmark our budget, at least 30 to 40% of our mooting budget, to identify, the Vienna ADR or Vienna arbitration, the Hong Kong arbitration, the ADR competitions within the country, outside the country. Our student, in our annual student festival, we have named one legal event after late advocate Ram Jethmalani, which he used to finance in the beginning. We thought of two areas. One was alternative dispute resolution, in that there are different types of competition. And second was monomooting, where the same person argues for both the parties. So we wanted the students not to become very litigious and adversarial, but to become more justice oriented in terms of dispute resolution. So the advantage of ADR focused teaching in institutions is that it is going to make students to be more justice oriented, more solution oriented than problem oriented. It is going to give them a very happy personality as well, make them more contemplative by being more client centric and client's happiness-centric approach, not wealth-centric approach, but wellness-centric approach. It's going to make a law school really quiver with that public service motivation. It will enrich its community extension and outreach programs. It will do a lot of good. They say that if you want to be great, you have to do good. So it will do a lot of good to the surrounding communities through the mission of the law school. Aside from that, there is also a smart side to this. You can also train your students to be researchers. You can train your students to be to be apprentices with your structured alternative dispute resolution structure. So if you ask me further questions, I can unveil some of those dimensions. Very
Thank you so much, ma'am, actually. I had this one question that mostly when you speak about mediation in law schools, it is clubbed with ADR as a whole. So is there something that you can tell me about mediation in particular, either in your curriculum or any programs that you have in your college?
Yeah, it's a very good question that you're asking, Neha. Mediation is seen as a kind of virtue I mean, it's really a lifesaver wherever relationships have to be protected. So it does least damage because it doesn't carry the aggression and damaging, flying what we call as firecrackers in the process. So mediation is more about understanding. So I made it mandatory that in family law cases, in family law course, students have to be trained in family mediation. And then in corporate law course also, they are taught how to do the business mediation. In case of healthcare law, how mediation is to be used. How do we use? We had this very interesting, my colleague, Dean Dr. Ajiv Eredekar, a wonderful medical expert, uh, once said that I will organize a global health conference. He said, I will outsource you the law track. So we were all, there was a media track, there was a communication track, etc. So I took my track very seriously. We were given 2 hours. So we decided to have, aside from discussion on mental health, which was very new by 2017, and medical tourism, we thought we will have a module on simulation. So we picked a real case. And in that case, the patient had died at the surgery table. And then the relatives of the patient were very angry. They were going to beat up the doctor. They were going to damage the hospital. And they had a very big expectation in terms of compensation. So they had filed a case in the Consumer Grievance Redressal Forum. So we enacted out this, where the students enacted, and a medical doctor sat, who is currently sitting member of Mumbai Consumer Commission. He sat as the judge. So the entire facts of the case and the decision of the case were enacted out in the form of a mediation. How there was a reluctant belligerent party and how the caucuses were created. So by this kind of simulation exercise, which you can see on the YouTube, the point was driven very strongly to the mixed audience that we had. So mediation is one mode of dispute resolution where you need not be a law expert alone, and where the law expert uses multiple expertises like psychology, counseling, communication, and also a kind of, I mean, if there is, let us say, somebody is not repaying you the money and you are doing a recovery case in the corporate context, arbitration is a more formal context, but less than arbitration is conciliation or mediation, where you can always have the party and a third party mediating between them and resolving this dispute. So the economic advantage, the hidden advantage, intangible advantage in the mediation approach is something that we make very clear to our students, and we want them to dominate this. I had a lot of girl students who excelled as mediation champions when they went for this competition. Some of them have been privy to this healthcare Health conference, which we conducted, global level conference. And then there were also, we have had mandatory training for students. Before they leave, we have a checklist of their skills. There is this new movement which we started last year under the leadership of Dr. Menon, just a few months before he expired, on what he called practice ready lawyers. I call it as profession ready lawyers. So there are certain skill checklists. So in that checklist, mediation and conciliation are the foremost kind of skills among other skills in dispute resolution. So we also have something called experiential learning. So mediation gives them that experiential learning. Becoming a client in the mediation also is a very interesting experiential learning. So when we do competition, we also give a separate prize for the best client. So law students taking over the garb of the client also is a good way of learning the other side, pedagogy, giving them that outside of the boundary or periphery kind of experience of the receiving person. So this is how we consider it as most important skill and most important capacity that a law student ought to have. And even for average people, it is important. See, when we trained these panchayat members, their mastery of the skill, they were able to apply it in their own cultural context. In India, we have lot of cultural mediators. And if we have an informal certification program of these people, it will be creating more and more dispute prevention avenues and dispute resolution avenues by good office, by opinions. The problem with these informal mediators is that they don't have the ethical anchoring and the professional monitoring which we have in our profession by councils. So if we can create a mediator council which will receive any complaints of such violation, then a mediation standards council you can create, within which we can monitor these traditional mediators. I've also seen some kind of illegal people engaging in mediation and then taking a cut out of the property or money that is involved. So some such bad practices can be prevented, but the virtue of dispute resolution can be utilized for the good of justice system. We have engaged as a law school in a very remote village with 200 smart women. Smart in the sense they're only 6th standard educated, but very, very smart in communication, very smart in picking up concepts of justice and law. So we want to train them as barefoot lawyers and as women who will be first responders in cases of domestic violence, especially in those villages child marriages are rampant. So we want them to engage in mediating between families and not allowing child marriages and getting the avenues for the girls to do higher education and not become victims of human trafficking or any kind of abuse or exploitation. So this is how mediation as a skill within the larger umbrella of dispute resolution can engage in social engineering and society building and community.
Thank you so much, ma'am. On that note, I'd like to say that I'm really thankful for your anecdotes, for your understanding, and I'm really thankful that you could take out some time for this interview. It was lovely talking to you.